The New York Times reports that thousands of the largest water polluters in the United States are outside the Clean Water Act's reach because the Supreme Court has left uncertain which waterways are protected by that law. As a result, some businesses are declaring that the law no longer applies to them, and pollution rates are rising. According to Environmental Protection Agency regulators, companies that have spilled oil, carcinogens, and dangerous bacteria into lakes, rivers, and other waters are not being prosecuted. They estimate that more than 1,500 major pollution investigations have been discontinued or shelved in the last 4 years. The Clean Water Act was intended to end dangerous water pollution by regulating every major polluter. But today, regulators may be unable to prosecute as many as half of the nation's largest known polluters because officials lack jurisdiction or because proving jurisdiction would be overwhelmingly difficult or time-consuming. Douglas Mundrick, an EPA lawyer in Atlanta, told the Times, quote, "We are in essence shutting down our clean water programs in some states. This is a huge step backward. When companies figure out the cops can't operate, they start remembering how much cheaper it is to just dump stuff in a nearby creek." According to the EPA, about 117 million Americans get their drinking water from sources fed by waters that are vulnerable to exclusion from the Clean Water Act. James Tierney, the New York State Assistant Commissioner for Water Resources, said of the new constraints, quote, "This is a huge deal. There are whole watersheds that feed into New York's drinking water supply that are, as of now, unprotected." EPA officials say that studies indicate that as many as 45% of major polluters might be either outside regulatory reach or in areas where proving jurisdiction is overwhelmingly difficult.